legislators have a responsibility when we pass legislation to have their interests in mind as much as the rights of the defendant. And it is absolutely critical that any legislation we pass here today or progress here today bears that in mind as we work our way through these SOPs.
The Honourable Rick Barker.
Mr Chairman, I want to speak on this criminal procedure reform and modernisation bill. And firstly, I want to congratulate the Minister for bringing this substantial piece of legislation to the House. I want to thank the Minister for his kind comments about myself and can say I do share his views on this piece of legislation. I was the Minister of Courts for some time, and I was the Minister of Courts for a time when we had queues of people extending out of the court. I looked at our court system as an administrator, not as a legislator or a lawyer. And when I looked at how our courts ran, I was dumbstruck. I could not think of a system which was as antiquated and as out of date as a court system. On numerous occasions, I don't know whether people here have read it, but those brilliant trilogy by Mervyn Peake about Gormenghast, the 74th Earl of Groan. He takes a pot shot at the British bureaucracy, British aristocracy, and how ossified they were. And the Earl of Groan has a master of ceremonies. And at certain points of the day and certain points of the week, he requires the Earl of Groan to undertake a certain ceremony, the purpose of which is long since forgotten, the meaning of which is completely irrelevant. But the Earl of Groan has to perform the ceremony. And it is just a mind-boggling process. Well, the nearest I've seen to the Titus Groan, the 74th Earl of Groan and the Master of Ceremonies, existed in our court system. There were procedures that went on which had absolutely no relevant meaning to the people there. They were required to turn up to court, there'll be a few words mumbled at the beginning, and then it'll be all over, and the person would leave again. And the defendant would say, well, what was that all about? The person who had interest, the victim, might turn up to see what was going on too, and they would say, what was all that about? Oh, it was a call over, it was this, it was that. And why would we do that? Well, no one had any, because we were required to. Because the Master of Ceremonies said we were required to. We had people turning up in large queues outside of our courts at 10 o'clock on Monday morning in a shambles. The whole place was paper-based. I have never seen so much paper in my life, and I said to the court staff, why have we got all this paper? They said it's because it's a legal requirement. You have to have paper. I said, well, we conduct all of these legal transactions in the Customs Service, and there's not a piece of paper anywhere. They're all perfectly valid legal transactions, and there is not a sheet of paper. But you'd go to court after court, and there'd be great stacks of paper hanging up there, perilously hanging over the staff. How they found the files, I never know. All of these things clogged up our court system. I started to make inquiries about what was going on. And I have to say, it was a bewildering network of overlapping, intersecting law which simply didn't work. Each court was taken as its own jurisdiction. Each High Court had its own systems. They had their own... It was an absolute muddle. And while all of this was sitting there, we had more and more people waiting to get through the court system. We could do everything we could to speed up the court system in terms of buildings and staff training, but the system overwhelmed us. And I started digging around, and I came across the work that the Minister has referred to, and it had stopped. It had simply stopped because it was too hard. And I thought of that at the time. I remember saying to some of my staff and Justice, well, shouldn't we have the words of Kennedy when he sent the space rocket to the moon? We go not because it's easy, we do it because it's hard. And the faces were a bit white, but we restarted the work. And I have to say that a lot of this stuff dates back to 1947, and a lot of the legislation and the way in which they did things has remained unchanged since 1947. And I'd often remark to the staff, well, have things not changed in New Zealand since 1947? Well, of course, Minister, they have. But nothing else has changed. And I want to say this is a fabulous piece of work, and I think that the real issue here for this Parliament is that we have had Ministers of Justice of all hues for many years who have been really interested in the important principles of justice, but very few have taken much interest in the administration of justice. And I think that is to the detriment of the justice system, and it reflects poorly on this Parliament. And I would hope that what happens subsequent to this piece of legislation is this Parliament continues to take, Mr. Chairman, continues to take a keen interest in the administration of justice, because it is the administration of justice which is critical to the public's perception of our justice system. If the public feel that the justice system is incompetent, Mickey Mouse, dare I say it, harking back to Gorman Garston, the Earl of Groan and the Master of Ceremonies, they will treat our justice system with contempt. The public have a right to expect that our justice system is administered in the style and the manner in which the rest of our society is administered. Fast, efficient and effective. I want to say that this is a fabulous piece of work, but there's much more to do. One of the things which was very dear to my heart was to get rid of the paper and have an electronic system. And I know the Minister is as keen on that as I am, and a lot of good work has been done. It's not going to happen overnight, but like the shampoo ad, it's going to happen. But it needs to happen because we have files which are missing, files which only one person can deal with, and so on. What we have to have is electronic files so they can be accessible by all and processed much more quickly. I have looked at electronic systems overseas, and I'm deeply impressed with how much more efficient they are than what our paper-based filing system is. We need to get on and fund and improve the legislation so that we have an efficient administration of justice. Can I come back to the issue of jury trials? I want to say that I agree with the comments made by the Minister of Justice when he talks about the Bill of Rights and about the obligations of the system to take into account the interests of the victims as well as the interests of the defendant, and that the critical part of this is to have a system which brings brings cases to trial for decision quickly and promptly. We still have an unacceptable delay. But I think there is another argument in favour of shifting the threshold for jury trials. And I'll put it to the Green Party this way.
Thank you.
It's a practical observation, because I'm a practical person. And I want to go back the truck to another part of my job, which was I was responsible for dealing with and making recommendations to the Governor-General on royal prerogatives of mercy. And I had a case come before me from a man who had committed rape quite some long time ago. And this conviction for rape was impeding something he wanted to do, which I won't tell you. But I went through the case, and it was that a young woman who was a friend of his came by his house one night to see the man's partner, and he dragged her into the bedroom and raped her. This was a premeditated act, a brutal act, and when I read the case notes, the trial decisions were very short in the late 1950s. I was quite surprised about it, but I was revolted. But the thing that struck me most about the case was the man got, for that rape, 1 year's jail. Now, in this context of this Parliament today, that is unthinkable, utterly unthinkable. And I say to the Green Party that many of the cases that were heard at that time would have had a similar threshold. What has happened in the last 30 or 40 years is the sentences we impose for things have shifted dramatically and have gone upwards. To have had a 3-month threshold when it was put in the 1940s would have been a very significant offence. The only thing which hasn't changed in this time has been the threshold for a jury trial. Had we have had some process of indexing the threshold of the jury trial to the types of cases and the terms that would have been expected, I would say to the Green Party we would have arrived very easily at a threshold for a jury trial much higher than what's been proposed here, and nobody would have said a thing. A jury trial in the 1950s was a rare thing because the threshold was high. But what has happened over succeeding generations of parliaments is that we have raised the thresholds for cases. We have raised, the stakes in terms of what the penalties could be, but we have never raised the threshold for a jury trial. Now, if you think about the 1950s, rape, 1 year sentence, a jury trial at 3 months, you are talking about a very serious offence. Now, if we do, Mr Chairman,
Honourable Rick Barker.
If this Parliament simply refused consistently along the argument of the Greens' view that 3 months was sacrosanct, I would respectfully suggest to the Green Party that in, say, 40, 50, 100 years' time, a person would have access to a jury trial for a parking ticket. Well, I'm going to say to you, because the threshold would get that. Everything else moves, but the threshold for a jury trial doesn't. Now, I just want to say that there are times when this Parliament has to say that when all of the other elements of the justice system are moved, then it's time for us to move the basis for a jury trial. I just think that's a practical observation of it, as well as the observations that other people have made as well. There are many things that can be said about this bill. I support it, and I think it is a very good piece of work. I commend the Minister's efforts for it, but I also think that we are going to have to come back to my theme, look at other elements of this. One of the other pieces of legislation that does need updating is the Judicature Act 1908. It's a fabulous piece of legislation. In another life, I had to make submissions on, for example, people who had been erroneously paid their holiday pay and had been overpaid. I always quoted the Judicature Act 1908. Section 92A. Section 92A.
That's right.
Exactly right. And I have to say to you, Minister, it won the case without anybody else, because no one knew about the Judicature Act 1908. They said, wow.
Altered your position in reliance.
Exactly.
Correct.
It was a fabulous piece of legislation. But the point about this is that the Judicature Act covers a vast array of things. It's out of date. And again, when I suggested that we embark upon a rewrite of the Judicature Act 1908, the officials went white as well. Again, because it is very, very difficult. But I want to say to the Parliament and say to the Ministry of Justice, these are things that have to be done not because they're easy. We have to do them because they are hard. And we have to do them to make sure that the administration of our justice system is what the public of New Zealand expects. Everything else is being administered differently and improving in its pace and efficiency, and there's no reason for us to have an antiquated system of administering our courts. None whatsoever. And I don't believe that we should be having a pile of people turn up at 10 a.m. on Monday morning to have to wait there till 2 or 3 o'clock in the afternoon for their case to be heard. No hospital sends out a note saying hip operations on Monday, tell everybody to turn up who needs a hip operation at 10 o'clock, and then you wait your turn for the surgeon to come to you. No one else does that, but our justice system does. There are many other aspects of our justice system which continues to practices which were appropriate and okay in the 1940s and early 50s, but it is not okay today. And this Parliament must continue to update the administration of justice, because if we do not do this, the perception the public have of our justice system will fall well behind, and they will not be getting the system of justice that they deserve. Thank you.
Very good.